Welcome to the Deep Dive, where we unpack complex topics to give you the insights you need. Today, we're tackling something really fundamental in Canadian professional practice: professional authority in engineering and geoscience.
We're looking at the legal muscle behind associations like uh, PEO in Ontario, EPEGA out in Alberta, Engineers and Geoscientists BC. These aren't, just social clubs. They have significant legal power granted by the government to actually regulate their own members.
And then that's our mission today, right? To really get under the hood of that power. How does an association go from, say, setting standards on paper to actually prosecuting a huge company or even taking away someone's license to practice?
It's a fascinating setup. Immense power, state-sanctioned, but it all relies on the profession policing itself with integrity. Public trust is key.
Okay, before we dive deeper, though, a quick word for those of you maybe studying for your license or gearing up for exams. Listen, if you're serious about really getting this complex regulatory stuff and you want targeted insights, expert strategies, particularly for things like the NPPE exam, well, you need to subscribe, like right now. Hit that button so you don't miss out on the analysis designed to help you succeed. Okay, don't wait. All right, so let's talk about this self-regulation. You called it a privilege, which it is, but where does this power actually come from? It seems huge.
It is huge,
Yeah.
and it comes directly from provincial and territorial governments. Through laws like the Engineering and Geoscience Acts, they have slightly different names maybe, but the function is the same. These laws literally delegate the authority to the associations.
Delegate the authority.
Yeah, and it's a trade-off, really. The profession gets the legal right to manage itself, to police its own ranks. But that comes with a massive responsibility. A duty to protect the public interest above all else. Maintaining public confidence is paramount.
Public protection, always the bottom line. So what specific powers do these acts give the associations to fulfill that duty?
You can break it down into about 4 core authorities, really the pillars of their regulatory power. First, and maybe most obviously, they control who gets in. They have the sole power to license qualified practitioners.
Engineers, geoscientists?
Exactly. Individuals and the firms they work for or run, they manage the gateway to the profession.
Okay, that makes sense. Controlling the entry point. What's next?
Well, once people are licensed, the association needs to oversee them. So second, they have the authority to investigate complaints.
Complaints about misconduct or incompetence.
Both, yes, allegations of either. And third, flowing from that, they have the power to discipline members if those investigations find wrongdoing.
Right. Investigation leads to potential discipline. And the fourth pillar.
The fourth one is distinct. It often gets confused with discipline, but it's outward-facing. It's the power to enforce the law against people outside the profession, specifically against unauthorized practice, people doing engineering or geoscience work without a license or using protected titles illegally.
Ah, okay. That's a really important split. So policing outsiders versus judging insiders. Enforcement versus discipline.
Precisely. Keeping those two functions clear in your mind is key to understanding how these associations operate.
Let's dig into that first one then. Enforcement. Protecting the boundary.
Right. Enforcement is about making sure only licensed people are doing the work that requires a license and, crucially, using the titles. Think professional engineer, P&K, professional geoscientist, PGO. Those titles are legally reserved.
Why is policing the title so important? I mean, if someone calls themselves an IT engineer but isn't designing bridges, what's the harm? Why go after that?
Well, because the title itself is the public's guarantee. It signifies that the person has the education, the experience, and, importantly, is accountable to the association and its ethical standards.
Ah, so it's about trust.
Exactly. If anyone could use the title, it becomes meaningless. The public wouldn't know who's actually qualified and accountable. Protecting the title protects the public.
Okay, that makes sense. And this isn't just theoretical, right? There are real cases. You mentioned one involving the OIQ in Quebec.
Yes, the Ordre des Ingénieurs du Québec case against Microsoft Canada back in 2004. It's a classic example.
Microsoft. What happened there?
Well, Microsoft was using the term engineer in its certification title. Microsoft Certified Systems Engineer, or MCSE. The OIQ took them to court in Quebec, arguing that this use of engineer infringed on the protected title.
Wow. A provincial body taking on a global tech giant over a job title, and the OIQ won.
They did. The court agreed with the OIQ. It was a landmark ruling, really.
What was the bigger impact of that win?
It strongly reaffirmed the legal authority of the associations, granted by the provincial acts, to defend the integrity of that title. It basically sent a message nationwide. These titles are legally reserved, and associations will enforce that, even against major corporations, if there's potential for public confusion.
So for anyone listening who's working towards that PNGO or PGO, that title carries serious legal weight and protection.
Absolutely. It's not just letters after your name. It's a legal status.
Okay, so that's enforcement guarding the gates. Now let's shift inside to discipline. This is about licensed members who, well, mess up somehow. What kind of behavior actually counts as professional misconduct? It must be more than just making a technical mistake.
Oh, definitely. It's much broader. Because professionals are held to a higher standard of conduct than the general public. So yes, misconduct can include technical failures like negligence or incompetence in their work, but it also covers things like dishonesty, conflicts of interest, breaching confidentiality.
And the code of ethics comes in here, doesn't it? These aren't just suggestions.
Not at all. That's critical. The codes of ethics established by each association aren't just guidelines, they are legally binding. They're usually incorporated directly into the Provincial Engineering and Geoscience Acts or their regulations.
So breaking the code of ethics is breaking the law, essentially.
In effect, yes. It makes a breach of ethics a clear trigger for disciplinary action. It gives the code real teeth.
What about behavior outside of work? Can someone be disciplined by the association for something unrelated to their engineering or geoscience practice?
Yes, they can. And this really highlights that higher ethical standard. Associations can and do discipline members for criminal convictions or other regulatory offenses if those offenses reflect negatively on their honesty, integrity, or trustworthiness.
Like fraud, for example.
Exactly. Things like fraud, embezzlement, maybe even serious tax evasion in some cases. Anything that fundamentally breaches the trust the public places in a professional. Because if you can't be trusted in your personal or financial dealings, how can the public trust your professional judgment when safety is on the line?
That makes sense. It's about maintaining the integrity of the profession as a whole.
Precisely. The association has a duty to act to protect that public trust.
Okay, so we know what can lead to discipline. How does the process actually work? It needs to be fair, right? Quasi-judicial, you called it.
Absolutely. Fairness and due process are paramount. While procedures might vary slightly province by province, the basic structure is quite consistent across Canada. It generally follows 3 distinct stages.
All right, let's walk through them. Stage 1.
Stage 1 is the complaint and investigation. It usually starts when someone, a member of the public, a client, maybe even another professional, submits formal complaint. The association staff will first review it. If it seems frivolous, it might be dismissed quickly. But if it appears to have merit, a formal investigation begins.
Gathering evidence, interviewing people.
Yes, collecting documents, maybe hiring external experts if needed. A thorough look into the allegations.
Okay, investigation complete. What happens then? Stage 2.
Stage 2 is the review by the complaints committee. This committee, made up of professional members and sometimes public representatives, reviews the investigation report and all the evidence. They act as a filter, ensuring due process. They decide if there's enough evidence to proceed.
What are their options?
They generally have 3 choices. They can dismiss the complaint if the evidence isn't sufficient. They might issue a caution or a warning letter directly to the member, sort of lower-level resolution.
Right.
Or, if the matter is serious enough, they refer it for formal charges.
And that referral leads to?
Stage 3, the formal discipline hearing. This is the most serious stage, conducted by a separate body, the discipline committee.
Separate from the investigator.
Absolutely critical. To ensure impartiality, none of the people involved in the investigation can sit on the discipline committee hearing the case.
No, it's like a trial, in a way.
Very much so. It's quasi-judicial. Evidence is presented, witnesses can be called and cross-examined, legal arguments are made. And importantly, these hearings are usually open to the public.
Transparency. Okay. And if the discipline committee finds the member guilty of professional misconduct, what are the potential consequences? They must be significant.
They are significant, reflecting the seriousness of upholding professional standards. The range is quite broad. It could be a formal reprimand or a written warning that goes on their public record.
More serious?
More serious could involve fines or requiring the member to pay the costs of the investigation and hearing, which can be substantial, tens of thousands of dollars sometimes.
Wow.
They can also impose conditions on the member's practice, like mandatory supervision, further training, or restricting the type of work they can do.
And the ultimate penalty.
The most severe penalties are suspension of the license for a set period, or outright revocation, permanently removing their right to practice and use the title.
Taking away their livelihood, that really underscores the responsibility that comes with the license.
It does. It shows the system is designed primarily to protect the public, even if it means removing a member from the profession.
Now, are formal discipline hearings the only way issues are dealt with? It sounds like a very heavy process for, say, a minor fee dispute.
That's a good point. No, it's not the only way. Most associations also have mechanisms for alternative dispute resolution, often called ADR, things like mediation or arbitration.
And what's the purpose of ADR here?
It's mainly for resolving less serious issues, often disputes between members and clients about things like contracts, fees, or maybe minor service quality issues that don't really rise to the level of professional misconduct.
So, not for negligence or ethical breaches.
Definitely not. ADR is voluntary, it's confidential, and it's usually much faster and cheaper than a formal hearing. It aims for a resolution that both parties can agree on.
But there must be a limit. What if something serious does come up during ADR?
That's the crucial failsafe. If, during an ADR process like mediation, evidence emerges that suggests actual professional misconduct, negligence, incompetence, unethical behavior,
Yeah.
the ADR process stops immediately. And a formal complaint is usually initiated to go through the investigation and potential discipline route. Public safety always takes precedence over a quick resolution.
That makes sense. Now, shifting gears slightly, this whole system enforcement, discipline, ADR, it relies heavily on the professionals themselves, doesn't it?
Absolutely. We often talk about collective accountability. The integrity of self-regulation doesn't just depend on the association's staff or committees. It depends on every single licensed member.
How so?
Well, the codes of ethics in most provinces explicitly state that members have a duty to report.
Report what?
To report incompetent or unethical practice they might observe in their peers. It's not just an option. It's often a professional obligation.
That sounds tough. Reporting a colleague.
It can be, but it's seen as essential for protecting the public and the profession's reputation. Members also have a duty to cooperate fully and honestly if the association investigates a complaint, even if it involves them or their colleagues.
Is there protection for people who do report whistleblowers?
Yes. Generally, the acts include provisions to protect members who report concerns in good faith. This is vital to encourage reporting without fear of reprisal.
Okay, so members policing members. But ultimately, the association itself holds this immense power delegated by the government. How is the association held accountable to the public? How do we know they are doing their job right?
That's the final piece. Public accountability. Even though they are self-regulating, they aren't operating in a vacuum. There's government oversight. A key mechanism is requiring public representation on the association's governing council and, very importantly, on the discipline and complaints committees.
So non-engineers, non-geoscientists sitting on these committees.
Exactly. Lay members who represent the public interest. Their presence helps ensure decisions consider the public perspective, not just the professional one. Plus, associations typically have to submit annual reports to the government, undergo audits, and make their disciplinary decisions public. Transparency is key.
Okay, this has been incredibly clarifying. We've really traced the lines of authority. We've seen the legal basis for self-regulation, this unique privilege and duty. And crucially, we've separated enforcement, policing the boundaries against unlicensed practice and title misuse, from discipline holding licensed members accountable to high ethical and technical standards through that clear three-stage process.
And understanding the distinction, enforcement versus discipline, and the processes involved is fundamental for anyone practicing or seeking to practice in Canada. But it leaves us with a thought, doesn't it? This whole powerful system of self-regulation ultimately hinges on the willingness of individual members to uphold the standards and, when necessary, report those who don't. So the question for you, the listener, is how does that constant internal pressure, that collective responsibility to police yourselves, actually shape the culture and the future ethical direction of engineering and geoscience in Canada, especially as technology and society bring new challenges?
That's a great question to ponder. Definitely food for thought. Thank you for joining us on this deep dive into professional authority. And remember, if you found this valuable, and especially if you're navigating the path to licensure or facing exams like the NPPE, make sure you subscribe. Hit that button now. We provide the focused content you need to be